Mwambie niko na meeting na wakubwa bwana.
Okay, you've been unmuted.
Good afternoon, colleagues. Hello. 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 Hello.
Thank you, Director Tabu. We can hear you now clearly.
Yes.
We can hear you, Tabu, just that we were not being allowed by the
Tabu, I can be able to hear you.
Thank you so much.
Hello, Tabu, I can hear you.
Okay, order now.
Tabu,
we can now mute ourselves.
I can hear you.
Thank you. Good afternoon, members. Welcome to today's discussion. And we are delighted we have 29 participants out of the 35. Kindly, members, let's mute ourselves. Makrin Kanjogu, Rosa wangu, naomba mweze kumute. Asanteni sana. Welcome to today's discussion. We are going to be having ladies in Zo, kindly mute. Thank you so much. We are going to have a good discussion today for the members of Kenya party so that we can have an opportunity to deliberate about the Building Bridges initiative. And in today's discussion, we are going to look at some of the specific topics that have been proposed by the Building Bridges initiative, topics that are going to touch on political parties, some of the key reforms that the BBI propose or may either better or not better our political parties. So we'll have a discussion in regards to political party reforms, the proposed system of governance under the BBI, how are political parties going to play a very very critical role in the new structure of governance proposed by the Building Bridges Initiative document. And then we're also going to look at some of the electoral reforms that are going to affect our electoral body. We are also going to have an opportunity to look at the Campaign Financing Act. And also another thing that is raising so much question is the issue to do with the 2/3 gender rule and also the inclusion of young people in the Building Bridges report. And we have advocate, Madam Rosrine Odede, who is going to be leading us in that discussion, and we'll have a whole 1 hour presentation so that she may highlight some of those key reforms that have been proposed by the Building Bridges Initiative. From CMD Kenya, want to welcome you all members. Feel free to engage after her presentation. Feel free to ask those critical questions that the members are feeling that they may not have had an opportunity before to ask, so that if at all we're going to have a referendum or the roadmap of the BBI, at least every Kenyan can be in a position to engage intellectually and from a point of information. At this moment, let me welcome Director Tabu, who is going to be our moderator of the day, so that he may welcome the members officially, make the opening remarks, and invite Madam Rosrine to begin the facilitation. Director Tabu, karibu sana. Director, kindly unmute. Director Tabu?
Hello. Good afternoon, members. Good afternoon, members.
Good afternoon.
Good afternoon, Bonaidi.
It's a great opportunity to have
Good afternoon.
and to engage on this matter. It's a great opportunity for all of us to have to say that which we need to say as we listen to the presentation of Madam Council Odede. And before I invite Council Odede, allow me to invite the Deputy Chair just to say jambo and to say a word. Karibu Bwana Kabala.
Good evening, members. Can you hear me? Hello?
Yes, we can. Good afternoon.
Good afternoon. Kabala Kili is my name, and I'd like to welcome you all to today's meeting. And as PD has said, today is our day to talk and express our feelings towards the BBI project, you could say. And let's all share and be open about it, so that you can, by the end, hopefully by the end of the meeting, can have a way forward. I'd like to thank you for your time, and karibuni sana. Thank you.
Hello. Madam Council, carry on. Hello. Hello.
Okay, good afternoon, everyone. Thank you very much for being here and for joining this session. I'd like to thank the leadership of NAC Kenya Party, the vice chair who's present, and the ED who's present, and all honorable members present. I'd also like to thank CMD for hosting us this afternoon through this session. I think Isaac has set the tempo for what we're going to discuss, and I think Tabu and the vice chair have also highlighted what we intend to see as an outcome from today. So, karibuni sana. I'll try and take you through this in a not too fast, but not too slow manner so that we can catch up with time. I see we already be quite late in the day. I'll start off by talking about the BBI and give just a small historical background. Now, we are all aware that the BBI was an offshoot of the handshake. The BBI was an offshoot of the handshake. And after the handshake, the two, which is the president, His Excellency the President Uhuru Kenyatta, and the former Prime Minister Raila Odinga, identified certain 9 issues which they felt were bedeviling this country and taking us back. So they agreed to set up a task force to look into the 9 issues, and the task force was actually labeled the Building Bridges Initiative. So the task force did its work and actually produced a report in October of last year. And post that report, it was agreed to have validation processes taking place. And this steering committee report produced in October this year is a result of the validation processes. Now, one of the things you'd want to ask yourself is how inclusive was that validation process? Did it reach the grassroots? Did it reach a majority of Kenyans? And those are the questions most will want to ask. And this is because you will see a lot of people asking to amend the document. The only reason they would be asking to amend the document is because their views were not taken on board. And that means the validation was not as broad, extensive, or exclusive as would have been intended. If you look at the document itself, it shows that they did not reach more than 400 institutions and individuals. And beyond that, they only went to 7 regions. Not counties, not constituencies, but 7 regions. And in each region, they spent less than a day. That just indicates that there was no grassroots effect, and also that there was no grassroots effect, and that also there was no reach to a broad cross-section of Kenyans. Kenya is a country of over 47 million people. And when you tell us that you only contacted 500 institutions and individuals, I think there's a gap in civic education and awareness that can be identified. The other thing with the process is I think part of it was overly politicized at the time that the validation was going on, because we saw certain rallies being held, and the rallies were overly politicized, and speakers were only allowed to address the gathering depending on the side of the table they sat. And I think this is also very, very challenging, and it's part of the reason the response to the final document is being very, very contentious, because the process was not inclusive from the outset. So those are just my observing remarks generally about the document. There are lots of apprehensions and fears about Kenyans, but I'm not going to talk about them because that might impose a bias into your views or otherwise. Scenario building, I'll not do that as well now. So I'll quickly just go into the document and just see what is there for political parties, what is there for electoral reform. And if you look at the document, if you've read it, you'll notice that it comes in various parts. We have administrative proposals, we have policy proposals, we have statutory proposals, and we have constitutional reform proposals. Today, we'll be looking at the administrative, statutory, and constitutional proposals. So to start off, I'm going to start looking at what are the administrative proposals in the document. The first one that they suggest there is the strengthening of the office of the Registrar of Political Parties. The concrete proposal there is to appoint a substantive office bearer. But we all know that has been done. So you can see that in parts and bits of this document, it's outdated and not in touch with reality. It also talks of implementation of the Political Parties Code of Conduct, implementation of the Political Parties Act and regulations, and implementation of the Elections Act and regulations to the letter. Again, these are interesting to have in the report because I don't think we need any decree or any further law or any judgment of a court to implement these things. There's a substantive office called the Registrar of Political Parties, and it should be working with these documents and the IEBC as well. So if they're failing, then we should be looking at institutional weaknesses rather than talking of implementing. I think that would have been a better way to approach it. The other thing they talk about is devolving political parties to have strong county-based branches. Now, this is something most parties probably do not achieve, but I know quite a few parties have managed to achieve the strong 24 branches countrywide. And I believe NAC Kenya is one of those ones with very, very strong county-based branches. But I think this is in recognition of the fact that sometimes the counties do not have as much clout and power as the headquarters. But yeah, I think that's a good recommendation for political parties. It is proposed that we go to the next election with new commissioners at the IEBC. They recognize a serious trust deficit in respect of the IEBC, and therefore they want the commissioners changed. But as we look into the document, you will see that now here they're saying a clean slate, but in parts of the document, they talk of vetting the sitting commissioners. So it's not clear whether the way to go is to vet the existing commissioners or whether they are suggesting that we send them all home and start again. But this idea of sending commissioners home with every election is also very disturbing. It makes one ask themselves the question that, is it the individuals who are failing or is it the system that is failing us? Because it can't be that every set of commissioners are not able to give us a clear, credible election, and every set of individuals are not able to earn the trust of Kenyans when it comes to elections. So I think maybe we are missing the point. We're always focusing on cleaning the commissioners at every election and not cleaning up the electoral system. And I'd like to hear your views on this when we come to plenary. Still focusing on the software at IEBC, they propose that the staff be serving on 3-year contracts, renewable ones. And they also propose that returning officers be hired in a very, very transparent process, much like we do with commissions in the country. Still on returning officers, the proposal is that they work on part-time basis and they should not oversee more than one election. Still the story of mistrust in individuals and forgetting that the individuals work within a system and that changing individuals may not achieve a credible and acceptable result to Kenyans. They again still talking on people. They want senior officers to be vetted for suitability to continue in service and for the commission to reflect the face of Kenya. Now, an interesting proposal in the administrative proposals is that they reform the present electoral system to ensure it is simple, accurate, verifiable, secure, accountable, and transparent. What I ask myself when I read this is this an admission that the current electoral system does not meet these tenets? And if it is an admission, then it means that we've been carrying out unconstitutional elections because these provisions are in the current constitution. And if we are saying reform the electoral system to ensure it meets these qualifications, then this is a very, very big impeachment on the electoral process and system that we have in Kenya. Now, to move to the constitutional amendments, the proposed amendments in the constitution that touch on elections and politics and political parties, I will start with the proposals relating to the IEBC. Now, it is proposed that the IEBC be recomposed of 7 commissioners and that the new team should be in place within 60 days of the referendum coming to pass. Out of the 7 commissioners, it's proposed that 4 of them shall be from parliamentary political parties. Parliamentary political parties. I think that should be worrying any party that doesn't have a strong presence in parliament, because this excludes all other political parties. And these 4 parliamentary political parties want to control the electoral management body. Therefore, they should be in charge of the elections to the exclusion of all other political parties which are not parliamentary. I think this should be very, very worrying to anyone who is not sitting in there. Then it also talks of current commissioners need to be vetted for suitability within 30 days. Now, the vetting panel for the current commissioners, and this is what I talked about earlier, that on the one hand, they're saying they should be a clean slate, but within the draft bill, they are saying that they should be vetted for suitability within 30 days. Maybe the vetting is just a mechanism for their removal, and the output is already predetermined, and that's very, very interesting. And when you think of that and you go back and reflect and tell yourself, it's these current commissioners who are going to run the referendum. If they know that this bill will result in their vetting and removal, is there a conflict of interest? Are they going to give us a clean referendum? Are they going to play around with the outcome of the referendum to protect themselves and shield themselves? If that report itself is saying that the current commissioners are not trusted by Kenyans, should we trust them with an entire referendum? Questions that come out of that. Now, the proposed vetting panel that they are proposing proposes that the chairperson shall be an advocate of the High Court of Kenya with qualifications equivalent to that of a Supreme Court judge. That means 15 years post-admission experience. It also talks of 2 members nominated by political parties, 1 from the majority party and 1 from the minority party. Again, very, very non-inclusive of parties that are not within parliament, and we neither the majority or the minority. I think these are things that should be spoken to. You can see some parties wanting to take total control of the IEBC and any processes that touch on the IEBC. Then it talks of 2 members nominated by a joint forum of religious groups and the PSC to offer secretariat services. Still on the IEBC, currently in the Constitution, the IEBC has power to determine election disputes arising from nomination of candidates and the list of candidates presented to it. It is proposed that this power be taken away so that the IEBC concentrates totally on preparing for the elections. Then it provides that Parliament shall enact laws for the timely settling of electoral disputes arising from nominations of candidates. That's okay. And then it provides that the IEBC shall ensure that the lists that it receives from political parties conforms with the provisions of Article 54.2 and Article 81B of the Constitution. Article 54.2 relates to the progressive attainment of 5% PWDs in leadership, and Article 81B relates to the gender parity rule, basically the 2/3 gender rule. Now, proposals relating to the National Assembly and Senate, these are vast and many. The first proposal there is that the National Assembly shall now consist of 363 seats with multi-member seats. In these 363 seats, there's no provision for the 47 county women, which are currently there in the Constitution. And that is a rollback in gender gains in terms of getting women into the assembly. The other thing that is provided there is the provision for nominations is struck out, so that the clauses that provided that parties may nominate youth, gender, PWDs, minorities, and marginalized have been deleted, have been proposed for deletion. I think that's also very, very worrying because one, these were affirmative action clauses, which were gains that were inputted into the Constitution. To delete them and make no provision for how gender balance will be achieved, how youth and PWDs and minorities will be included into the parliament, I think is very, very worrying for any party. Beyond that, also, the provision for nominations gave parties some clout in terms of getting some seats, extra seats in the assembly. So I think this is very worrying. It's a clawback, a total clawback on gains made in the 2010 Constitution. Now, beyond that, again, the 363 seats with multi-member seats are not well defined. The one thing that's defined and agreed is that there'll be 290 constituencies. That gives us 70 extra seats to deal with. The steering committee report has no provisions, completely no provisions on how the 70 members shall be identified and how the 70 members shall get into the National Assembly. There's completely no mention of them, either in the proposed constitutional amendments or in the statutory amendments. And this is very, very worrying because unless the provision of how the 70 will be identified, elected, nominated, or whatever the word is concretized in writing in the draft constitution, we are leaving this open to the power players to determine at every election how the 70 will be identified or elected. And I think this is very, very worrying. We need a succinct provision that tells us where these 70 are coming from. But the explanation they've so far given, and which is not in the document, and which is being given to people verbally, is that the multi-member seats shall be given out on the basis of population density, relying on the last census, which census data has been greatly disputed across the board. So they say they will rely on population density to distribute these seats. Now, when we go on population density, one question that comes to mind is this backdoor boundaries review, a way of giving constituencies more constituencies without doing the proper boundaries review, a question that stays out there. And how will these 70 seats be affected should a boundaries review occur? Would we just have more constituencies and still keep the multi-member seats? Those are questions that need to be answered with a lot of clarity. The other thing is we must realize that going by the population density, most of these seats are in one region, and this gives power to one region of the country to the detriment of all the others, because they will have more representation in the assembly and therefore more votes on any issue and more voice on any issue. And I think this is very, very dangerous, and we need to speak to it. We need clarity, and we need to be sure that whatever model is used promotes equity, promotes gender balance, promotes the youth, the PWDs, the marginalized, and the minorities. And I think we must speak to the absence of the 47 county MPs. Their presence in the National Assembly cannot be wished away. Those are gains that Kenyans and Kenyan women really fought for in the drafting of the 2010 Constitution. And I think these are gains that we must stand at the door to defend very, very keenly. Now, when it comes to Senate, the proposal is that there shall be 94 seats in Senate. This means, therefore, that every county shall have 2 senators of opposite gender. Now, the question that comes to mind is, do we actually need 94 senators? Or is this a blindfold to other ills in this constitution? Is this something to make women feel we've given you something on the other side, so it's okay if we take away from the National Assembly? In my view, we do not need 94 senators. The 47 senators are very apt and good. And it's very easy to meet gender parity in the Senate by just nominating 16 to 70 more people. So even the 94 is a burden in terms of Kenyans having to carry the wage bill. And it's not just the wage bill. There's a lot of allowances that go with these seats that are not documented in terms of calculating their wages. So I think this is a blindfold that we do not need, a sweetener that we don't need in there. Again, in Senate, nominations have been done away with. So we are not sure how we'll ensure that out of the 94 elected senators, that there are youth amongst them, that there are PWDs amongst them, and that there are women amongst them. I think there'll be no way of assuring Kenyans of this. And these are great drawbacks. This is just not nice. Okay, then the other provision in terms of the National Assembly is they introduce or reintroduce the provision of official leader of opposition, which is a seat they propose to give to the first runner-up in the presidential election and who has at least 25% of the seats in parliament. So where this person doesn't have 25% of the seats, it might force the individual to go into coalitions with other parties so as to achieve that 25%. Now, the other provision in terms of the National Assembly is how it integrates or interfaces with the executive. There's a proposal to have, in addition to the president and deputy president, prime minister and 2 deputy prime ministers. Now, you'll first ask yourself, why 2 deputy prime ministers when we only have 1 deputy president? What's then the magic number 2? Because when you look at the draft, there are no clear tasks or assignments delineated to each proposed deputy prime minister so as to distinguish between the offices of the 2. Is 2 just a random number to please some sort of political class or some sort of political leaning? I'm not sure, but there's no justification in the entire document why it is necessary to have 2 deputy prime ministers if it is necessary to have a prime minister at all. But the number 2 is not justified in the least. Secondly, you will find that the proposal is that the prime minister shall be a member of the National Assembly. So the prime minister shall first have to have been elected as a member of parliament, and post the election, the president can nominate a member of the assembly for appointment as a prime minister, and with approval of parliament, he becomes a prime minister. Now, the appointment seeks approval of parliament. The draft bill says the president can dismiss this person, but it doesn't make reference to parliament at this stage, so that provision for dismissal is left to the president. So we are creating a very powerful president here, a president who can appoint a prime minister and dismiss that person at will. And the same for the deputy prime ministers, a very scary proposition there. Then it provides that the prime minister shall be the leader of government business in the National Assembly and shall be in charge of the legislative agenda in the National Assembly. So this makes the prime minister a very key and important member of the National Assembly. In fact, if you look at the pecking order of the National Assembly, it is the speaker coming first, and then second is the prime minister. And it is noted as the prime minister, not the leader of government business. So he's there having a senior pecking order in the National Assembly as the prime minister, but sitting there in the legislature, in the National Assembly. At the same time, this prime minister is going to be in charge of the cabinet ministers and is going to be in charge of the functions of the ministries. Now, again, this same prime minister is a very, very key member of the executive. Now, this must worry anyone who knows about the doctrine of separation of powers, because the prime minister cannot be both a key player in the executive and a key player in the legislature. And we expect that the legislature will effectively oversight the executive. I think we are losing out on the powers of oversight. We are going to lose out on control. And the executive is going to be an animal that is so powerful that it cannot be controlled or contained by the legislature. This is worsened by the proposal that cabinet ministers also come from the National Assembly, and those cabinet ministers that are appointed from outside the National Assembly become ex officio members of the National Assembly. So I think we are eroding the gains of the Constitution. We went for separation of powers, and dilution of the powers of the National Assembly by giving the executive very, very key critical roles in the National Assembly is very worrying. So next we move to the county assemblies. And when we look at the county assemblies, the issues that come up, one is the manner of allocating party lists. And it is proposed that we move from the system of allocating party lists on the basis of the number of seats that a party has won and concentrate on the basis of the total votes received by a political party. So it will no longer be the seats won, but the total votes received by a political party. It is proposed that Section 177, which is the affirmative action clause, Article 177, which is the affirmative action clause, should have a sunset clause to it and make it lapse after 10 years. Again, drawbacks on gender gains, as I do not think gender will have caught up in 10 years, and that's very worrying as well. In the current constitution, the term of the assembly is stated as, of the county assembly, is stated as 5 years. This is different from the terms of the national parliament and the terms of president and terms for governor. For those others, it provides that their term lapses at the date of the next general election. So it's proposed to bring the county assembly in tandem with the others so that the life of the assembly lapses on the date of the next general election. A new provision is introduced for recall of MCAs. And I find this very interesting because I think it will keep playing out between the governor and the MCAs. Whenever there's a threat for impeachment, there'll be a threat for recalling. And whenever there's a threat to recall, there'll be impeachment. It's going to be very interesting to watch that going forward. It's proposed that the deputy governor be given a county executive role within the county so that they have a function that they're in charge of rather than being very idle. It's also proposed that all county executives should not lose their seats just because the governor has ceased to be a governor. And that's, I think, for continuity and good governance. There's a proposal that a candidate for governor should consider having a running mate of the opposite gender. Now, the word consider there is not drafting language. It's neither mandatory or otherwise. And I do not know why it found its way into the document. I think it should be made mandatory. If we want to have such a clause, it should just be made mandatory and probably apply to all offices where there's a running mate or a deputy. Provisions for Ward Development Fund and increase in revenue have also been proposed to try and empower county assemblies and improve their service delivery. So that is it for what I would call proposals that touch on the constitution and touch on political parties' activities and touch on elections and touch on the electoral management body. I will now move to the statutory proposals in the document. And they propose several amendments to several election-related laws. As we discuss this, I want you to remember that these are statutory provisions and they can only come into force through a parliamentary process. All laws must be passed by the parliament. So these are proposals, yes, but they are subject to a parliamentary process and anything can come out of this. They might be passed as they are, they could be rejected in totality, they could be amended so radically that they are no longer familiar, but let's take it in with that in mind, knowing that it is subject to a parliamentary process and may not see the light of day in the manner that we are discussing them today. But just knowing what is in the minds of the drafters gives you an idea of how to engage going forward in terms of electoral amendments, electoral law amendments. So yes, what is the first proposal there? The first proposal is that a voter, it redefines a voter to include a person who has not only applied, but a person whose name has already been included in the register. So this is to give the IEBC an easy task because we've seen people coming at the last minute and querying the register. This gives the register the final word on who is a voter. So one cannot come and claim that I have applied and I know I am registered. If you're not included in the register as a voter, you are not a voter. There could be mischief there that we need to look out to. It extends the period of closing registration of voters, so from 3 months to 4 months, to give the IEBC some time to prepare for the elections. The period for party nominations is also extended. Currently, party primary should be carried out at least 3 months to the election. It's proposed to extend this to 4 months to the election. There's a proposal to omit the full details of a voter's ID and passport number during printing of the register. Again, I see room for mischief here. I don't know if you do. Let's discuss it at that time. A good proposal coming through is that IEBC should publish the election timelines 18 months to the election, to the general election. I think this will be very, very useful because it will enable political parties to prepare themselves adequately, knowing very well and clearly the timelines that they are dealing with. In the past, the timelines have been very erratic and sometimes stated very, very close to timelines, making it difficult for political parties and aspiring candidates to meet those timelines. It also provides that agents must be registered at least 14 days to a general election so that the IEBC has ample time to clearly identify agents on the voting day. Still on the Elections Act, they say that an individual or a political party may ask for the register of voters at least 60 days before the elections, and they have a right to be given the register. It proposes to introduce criteria for nomination, credible nomination of candidates and credible development of party lists. The criteria includes the principles of democratic, free and fair processes, inclusive and participatory processes that give fair and equal opportunities to everyone, especially the special interest groups. It also provides for open, transparent, and accountable processes, credible processes, and most of all, peaceful processes. So I think those are powerful criteria there that would really improve the landscape for political party primaries and the general elections going forward. Still on the Elections Act, it provides that a registered member of a political party may up to 30 days before the party primaries object to the clearing of an aspiring candidate on the grounds that that person is not a member of the political party, the person is not qualified for the office for which he has been cleared, or that the nomination does not comply with the Constitution or the Act. So I think that's a very powerful provision there, giving individuals of a party or members of a party the right to query candidates that are being cleared for the party primaries. It provides that disputes can be determined within 25 days, and any appeal should go to the political parties tribunal. I don't know, but I think the 25 days is a little too long. If you're going to be lodging your complaint 30 days to the party primaries and 25 days are spent on the dispute, where is the time to appeal to the political parties tribunal? Or where is the time for the party to even come up with a new list of aspirants, especially where that may have been the only candidate? So those are issues to consider. Now, still on the Elections Act, the proposals are to establish internal dispute resolution tribunals in every political party. The disputes by these tribunals should be determined within 60 days and must be expeditious, efficient, lawful, transparent, and procedurally fair. It provides that a party may, in its constitution and in its rules, provide that before one can access the IDRT, they have to undertake ADR processes. They have to go for mediation or similar processes before approaching the tribunal. And it is proposed therein that where such a provision exists in a party's constitution, an individual cannot directly access the IDRT before attempting ADR. I don't know, but I think this is some sort of barrier to accessing justice because forcing one to submit to mediation, even where they know the result of mediation will not be useful, it just sounds like a barrier. And I don't know what you think from your political party. It provides that party lists are to be submitted at least 150 days before the election. This is 5 months to the election. Now, what is key here is that now the requirement is that party lists be submitted before party primaries are held. This has the effect of locking out party diehards who may go to the party primaries and lose out, and the party is still interested in supporting their candidate or their presence in an assembly because of the key role they play within the political party. So the provision for sending party lists 5 months to the election, way before party primaries are held, may not augur well for most political parties. I don't know how it sits with your party. For rights of agents, it provides that rights of agents include training, access to all documents that will be used for the election, and protection of the law. This is to protect them from violence and all other untoward activities that agents normally experience at polling stations or otherwise. Now, beyond the rights, there are also responsibilities of agents. And the responsibilities, I'll talk about 2 key ones there. One is that an agent is supposed to sign all official documents as required. I think this is a way of forcing agents to sign that the result declaration form, even when they're not agreeing to the context. And I think this can be very dangerous because once you put your signature and the document is taken to court as an exhibit, you will be deemed to have consented to the contents. So saying that the agent has a responsibility to sign it, whether they agree with it or not, I think there must be some sort of caveats to allow the agent to either put his concerns down or to refuse to sign, because it can't be mandatory that you have to sign. What if I don't have an agent? What happens to that document? So I think that's really unfair. Then the other provision responsibility I want to point out is the responsibility to remain within the polling station at all times. And where one doesn't do that, he's subject to a fine. And that will be an electoral offense. I mean, it's not nice because, you know, if you've got an election offense in your belt, you can't vie in the next 5 years. And I think this is really not a very good provision. Still on the Elections Act, it provides that independents must present their papers within 3 months to the election, and they must prove that they have not been members of any political party within those 3 months. So you can see this is opening up the provision where independents can move away from their political parties after the party primaries and come and vie as independents. I do not know what your views on that are, whether this is a good thing or a bad thing, whether it is good to encourage registered members of political parties to quit the party only after the party primaries. I'd like to hear your views on that. There's a provision that provides that PWDs that are registered members of a political party shall congregate on their own and elect their representative under Article 177. Don't know whether this is a good thing or it can cluster PWDs as having a special seat and therefore not being worthy of being elected to the mainstream seats. There's the danger of them being marginalized because people in their minds will start saying, see, they have their seats, so why are we electing them? So I don't know. I'd like to hear views on that as well. Now, election officers are to be appointed competitively, and those excluded from being election officers are those who have been convicted of an election offense in the last 5 years, those who have contested in the last 5 years, anyone who's an agent for a candidate, or anyone who holds office in a political party. And finally, in terms of the Elections Act, there's a proposal to make the declaration form filled at the polling station the primary form for tallying of results. It then provides that the commission shall determine the manner in which results are to be transmitted. I do not know why this is left to the commission and not made a firm provision of law, because why should it be at the whims of someone sitting at the commission to to determine how results will be transmitted. I think transmissions of results should be a legal matter, and because it's also a very technical matter and a very contentious issue normally in petitions, I think it should be provided for by law. It provides that the commission shall accredit media houses which can report on the elections. This again is, I think, a backdoor way of gagging the media, so that if the media house is controversial or is reporting things that the commission doesn't want to see or doesn't want us to know about, they shall not be accredited, or the accreditation shall be withdrawn even halfway through the election. So I think this is retrogressive. These are the things we moved from the days of KANU. And I think these are the gains when we gave the media freedom in the Constitution 2010, we cannot allow this kind of clawback. And then it also provides that a party may recall a nominated member on grounds of insubordination of the party, or on grounds that that individual is not advancing the interest of the party that nominated him, but is advancing the interest of another party. So those now are very powerful provisions, and I think they come from experiences that political parties have suffered after nominating people to take up certain seats. So those are the provisions relating to the Elections Act. We'll quickly look at the Political Parties Act. In the Political Parties Act, the main thing that is proposed is the manner of distribution of the political parties fund. And the provision there proposes to introduce a criteria that recognizes the number of women, youth, and PWDs elected by a political party, so that those who elect more will get more money, and those who elect less will get less money. And those who get none will not get access to that 45% of the fund. So this is supposed to encourage parties to have more women, youth, and PWDs being elected. But it doesn't resolve the two-third gender rule still. So we still need clear provisions for resolving the two-third gender rule. It also proposes that each party, each political party, should establish a dispute resolution committee at every branch. This is supposed to empower the branches and to also free up the headquarters from determining all sorts of disputes coming from all over the country. So the proposal then is that the headquarters shall be an appeals committee. And so appeals from the dispute resolution committees at the branches can come to the headquarters. I don't know what you think as political parties about that, and whether this is already being practiced by your political party. And then it provides that disputes should be determined within 2 months, of their being lodged. Now that is it for Political Parties Act, not much improvement being made there, but at least the Political Parties Fund actually looks for parity. Now, we talked earlier about the provisions relating to the IEBC as appear in the Constitution. But you know, we also have an IEBC Act. So there are proposals that relate to the IEBC Act. And one of the ones I would really point out is that there's a proposal that the vice chairperson cannot, should not, and cannot perform tasks reserved for the chairperson. Now, one of these tasks that I know is being targeted is the duty of announcing the results of the election, especially the presidential result of the election. And this played out in the last election. And I think this is supposed to be a way of ensuring that mischief is not played and the vice chairperson does not come to read results that have not been agreed upon by the entire commission. But the danger with putting it and wording it as it is proposed is that we are assuming the chairperson will always be available to perform this task. What if the chairperson is incapacitated for any reason, or the chairperson is abducted? I know I'm losing, so I abduct the chairperson. We'll be left in limbo, total limbo. Or what if, and touch wood of this, and God forbid, what if the chairperson ceases to be alive and passes on? I mean, it would be very, very dangerous to say that the vice chairperson cannot perform the task, or any other commissioner cannot perform the task. I think a better way of wording this would be saying that this task
This
is
is
reserved. I think a better way to say it is that this task is reserved for the chairperson, but in the absence of the chairperson, for the following reasons, X, Y, Z can happen. So in that way, we are reserving it to the chairperson where he's available, but where he can't be found, then we open the window so that we are not left in limbo and having conducted an entire election, not having an election result being declared. That would be very dangerous a scenario. Again, we go back to the staff. They provide that the secretary of the commission should serve on a term of 3 years and be eligible for appointment of 1 more term. It proposes to establish an IEBC fund to try and make the commission independent of the treasury and being able to receive even support from other entities to support the electoral process. I think the other day, last week or something, we saw the government writing and refusing to accept support towards election processes. I think now this will give the commission some sort of independence in determining that. Then there's a provision that the IEBC must make public on its website all information relating to its mandate and the electoral process. I think this will make it easier for people who want to, especially petition, to find access, to access the documents they need to support their petition easily by just going to the website and downloading them. So I think that is very, very useful and powerful. So that is it for the IEBC Act. Then there are proposals that affect the Election Campaign Financing Act, and there are just 2 proposals there. The first one extends the ambit of the effect of the campaign financing period. So it's extended from just the election campaign time to include the party primaries as well. So funds expended after the party primaries and ending just 2 days before polling all fall between the campaign financing period. Then it also provides that the limit set on the campaign financing period should have due regard to the benefits and remuneration of the office to which the limit relates. Finally, they propose amendments. Somebody's mic, please be muted.
Jared, if you can hear me, kindly mute.
Thank you. I think he is muted. So finally, they propose amendments to the Election Offences Act, and there are just 3 main proposals. The first one is to expand the ambit to which election offences apply. Currently, election offences only apply to election campaigns. So it's proposed to expand the issues around which offences may relate, and this includes planning and implementation of elections and referenda. It includes education of voters, period. It includes recruitment, appointment, and training of election officers. It includes testing and trial of electoral equipment. It includes registration of voters, nomination of candidates, campaigns for elections, and finally, it includes voting, counting, tallying, and declaration of results. So all these processes are subject to the Election Offences Act, and if anything occurs around them that amounts to an offense that is noted in the Act, it will be deemed to be so. And this is as opposed to currently where offenses only occur around election time. Then it's proposed to introduce 2 new offenses. The first one is where a person uses force, threat, deception, violence, or otherwise to compel a person to transfer their vote or to register their vote in a specific area. That is deemed an offense, and you can be fined up to 4 million, jailed up to 12 years, or both, or subjected to both. Then there's the other offense that deals with where a person harasses, intimidates, coerces, or threatens to cause physical harm to a candidate. Again, that is an offense, and the person can be fined up to 2 million Kenya shillings, can be jailed for up to 6 years, or can be subjected to both the fine and the jail sentence. So those are the two new offenses that are being introduced. And in relation to the offense of bribery, they propose to expand it to include the the nomination process. Right now, it only relates to the election period, but it's proposed that now bribery that occurs even during the party primaries shall be an offense within the meaning of bribery in the Election Offences Act. So those, ladies and gentlemen, are the proposals that relate to elections, political parties, gender, campaign financing in the BBI Steering Committee report. I thank you so much for listening to me, and now it's my time to listen to you. Asanteni sana.
Thank you very much, Council Odede, for that presentation. And members have heard you, and members have issues that they would love to raise. But as I invite members to make their responses, I wish to state that this process, as you have aptly put, actually is not constitutional because it has fallen short of Article 10. And I don't understand why people expect Kenyans to continue dealing with a matter that is unconstitutional from the onset. That is my position. I wish now to invite members. Just raise your hand in the chat. Then I will allow you to speak, to seek clarification, or to say whatever you want to say. And as members prepare to do the same, Council, help me to understand now that nothing has been said of this 70, and it appears like somebody is keen to do the unthinkable. From where you sit as a citizen who also feels like we are being marginalized, we are introducing boundary delimitations through the back door. We are causing confusion just because two people met and decided to share our cake. How do we safeguard the gains that we have made, Council? Hello?
I thought we were taking a few more
yes,
responses.
Yes, I'm saying hello to my colleagues so that then you can have about 4 when you respond. It looks
hello,
like
Losrino Dende.
Techno, raise your hand in the chat so that then we can.
I've already raised.
I am not seeing you in the chat having raised. Okay, proceed.
Okay, Losrino Dende, I wanted to ask you something about the Ombudsman office. When you go through the BBI report, they are talking about that he should give a report to the JSC and he can either propose somebody to be suspended or to go through a disciplinary action. So what I want to really understand is that is JSC bound to act on the Ombudsman report in terms of the disciplinary of the judicial officers after they have received the report from the Ombudsman? That is my question.
Council, you can respond to those two because it looks like there's nobody else as at now.
Okay, thank you, Edie, and for the opportunity. Let me start by responding to the question relating to the judiciary ombudsman. Now, this is a problem, again, that relates to separation of powers. The president wants to appoint a functionary in the judiciary. Why should that be? Why should the president have the power to appoint a functionary of the judiciary? You can just see here that this BBI is giving the president powers over the legislature. He's going to be appointing very key people there. He's now also being given powers over the third arm of government, which is the judiciary. And this should worry us a lot. This should really, really worry us. We all remember the judiciary was promised a revisit. We don't know whether this is a backdoor way of revisiting the judiciary. And you will see that the proposal says that after the president has appointed this person, the person will sit as a member of the Judicial Service Commission. Now that calls for us to go back and look at the composition of the Judicial Service Commission as currently constituted. And you will see that the executive already holds quite a number of seats in that commission. Added to it, the Judiciary Ombudsman, the executive shall have the majority members in the JSC, so that decisions of the JSC can be totally controlled by the executive. And that's the greatest fear with this judicial ombudsman, so that they can use him to dictate the activities, because now he tips the numbers and the power in the JSC in favor of the executive, so that decisions that go to JSC can always go the way of the executive. And that is the greatest fear with this judicial ombudsman being appointed by a president, and therefore we are creating an overly powerful and imperial president. So you're asking about whether his report must be adopted. No, it doesn't have to be adopted, but as I have stated, executive will have numbers and anything they want can see the light of day. So for instance, we saw this happening to the DCJ the other day, where when matters were coming up, she was picked up and charged with cases and here and there, so that you're excluded from sitting on a case that's coming before the court. And this can happen much, much more frequently with a judicial ombudsman, because he'll just say, I had this case, and file reports that Rosalind should be suspended. Rosalind should be suspended, yeah, and should be X should be suspended. So that all the big-headed in terms of being viewed by somebody else, all the judges who are deemed to be big-headed or stubborn will be put on suspension list while certain critical cases are coming up, just by the presence of this judicial ombudsman. So that's the one thing that we really fear, and that's the caveat, and that's the rollback that we are seeing with the judiciary being also interfered with by the executive. So I hope that answers you adequately in terms of what you asked. Tabu, you raise a controversial issue there by saying, according to you, this process is totally unconstitutional.
Yes.
And has fallen short of Article 10. It's actually, I look at it as an antithesis of what it set out to achieve. I mean, if we set out to achieve inclusivity, if we went set out to achieve unity, I see it's written, building bridges to a united Kenya. And then here you are, whenever people talk, you back at them, you know, it just doesn't work like that. So I think there's a problem that the proponents need to reconsider and redefine how they are engaging with citizens on this document, just to make sure that it works. The 70 seats, how do we safeguard gains? The only way to safeguard gains, Tabu, is to get your views across, to get them to accept that we need to rework this document so that we have consensus. Or the other way is to reject the document when it is presented. Now, what does that call for? It calls for extensive civic engagement and awareness at the grassroots. So I think as political parties, our work is cut out for us. You need to take a stand on which way you're going. And if you're going to protect the gains of the Constitution, then you must speak to the people. You must carry out extensive civic engagement with the Kenyans. Thank you.
Thank you, Council, for those responses. Colleagues, we can have round 2 of clarifications or any questions that we wish our Council to respond to. Let's the same format. Raise your hand, and then we will give you the opportunity. Who is ready to go? Macreen, you will take the first one, followed by Techno. Macreen, have the stage. Macreen, the stage is yours.
Yes. Thank you, Edie, for the chance. And I want to thank Roslyn for the comprehensive presentation on BBI, and especially for those of us who have not yet maybe read and understood the report. She has really taken us well, and mine is not just a question, it's kind of a direction, or a clarity or a direction. She should clarify, or maybe how I'm feeling. My concern is about the clause that speaks, or their clause, the BBI clause that they have. They have written about the gender rule and inclusivity. And as a country, I know we have come from far. We have been moving forward. We are not the way we were 5 years ago. We've been doing well. But on this BBI thing, I think it's not even giving us clear direction on how the gender rule is going to be met, or the inclusivity on youth and PWD. She has already explained that. So mine was not a question, it was just a concern or a clarity on direction on are we now going to throw the towel and say, let's go on with the BBI, and knowing well that it has not yet provided us the right direction, or it has not even clarified the direction on the gender rule. That is just I just want her to tell us what she thinks. Do we follow it blindly, or what do we need to do for us who are gender?
Okay, Techno.
Madam Roslyn, there is this issue about having these 290 constituencies and the 360 members of parliament. But when you look at the report, they are talking about the 360 are elected. So
Tabu, please carry on as I try and get through to Brian Gidinji. I think his internet connection has a problem, so I've muted him. Please carry on as I try to contact him.
Okay, fine. Techno will be sorted. Council, there is this challenge that Macreen is raising with regard to the 2/3 gender. Remember, as we speak, there is already an advisory to the head of state, which is constitutional with regard to dissolution of parliament. Even as we expect that parliament has to enact laws, do we have a constitutionally constituted parliament after that advisory from the Chief Justice that is constitutional? Over to you, Council.
Thank you, Tabu. I like your question. I like the way you put it. Now, the advisory, let's start from the advisory. The advisory is just that, an advisory until acted upon. What remains is probably now for LSK, which generated this, to go back to court and seek declaratory orders against the president's failure to dissolve parliament. And until it's dissolved, because dissolution is a fact, it's an actual, before it is dissolved, it is legally in place. You get what I'm saying? So until we take the next step of going back to court and getting a declaratory order, and that's where that's why some people say the law is very silly. So until we go back to court, take the next step and get the declaration that the president's failure to do this is tarara, and parliament now stands dissolved. that's when Parliament will actually ipso facto be dissolved. So we can't say they are unconstitutional. All that we have in place is an advisory. And what pains me is that despite the advisory, Parliament has refused to even do something towards showing that we are attempting to make good what is not right. And I saw people confusing this advisory. The advisory was not to deal with the current composition of Parliament. It was not addressing the shortage of members of Parliament or of women in Parliament. What the advisory was dealing with was the failure of Parliament to enact legislation that would give breath and life to the two-third gender principle. So the failure of Parliament to legislate is what is being dealt with. It has nothing to do with the numbers of women or men in the current Parliament. That's a distinction we need to get very clearly. And it would be very, very easy for the current Parliament to try and even take steps towards remedy. And their silence and total inertia in that direction really worries me. And looking at that inertia, and then looking at the BBI steering committee report, which is totally rolling back the gains on gender, and even removing or doing away with the 47 county women's seats, there is a conspiracy that is known to a few and not known to us. And that's why Kenyans must be the gatekeepers of their own. If we leave it to those people, we are going nowhere. We've got to be the gatekeepers of what we are dealing with. I think that's what I would say now, Tam.
Thank you. Council, we will take Q. Ngugi, over to you, please.
Yes, thank you, Bwana Tabu, for the opportunity. Now, my concern is on the proposition about women rep and moving them to the upper house, that is the Senate. So my question is that supposed to give them the oversight, and is it oversight to who or to what and over what? And still on that, is it taking away the allocation on the NGAF? And how will that help in making them useful to their counties? Or is it a case of making them flower girls? That is my question.
Harrison, the floor is yours. Kabui, take the floor.
The issue is on IEBC. Has it been by changing of commissions, augmenting them, and denying them the chance the independence change the outcomes and direction?
Okay, Harrison, if you are done, Council, kindly.
I'm sorry, I did not hear a word that Harrison said. Can he try and repeat himself?
Harrison, please, just, I think the issue Harrison is saying is
Yes.
the current focus on the individuals at IBC instead of the institution. So why should that be the matter? In what mischief are we curing by just focusing on if Chebu comes in? Is it any better?
Thank you. Thank you for explaining that. I missed it and I apologize. I can start there, and Harrison, as I said at the beginning, for me, I think it's a misnomer to be focusing on individuals at every election and not focusing on the electoral systems and processes. And you can see in the document, there is an admission that our electoral systems do not meet the constitutional threshold. that is set in the constitution. That is simple, accurate, verifiable, and whatever else is there. So we already have an electoral system that the report recognizes as not meeting the threshold. Why then is the focus on individuals? And why has this been our focus at every election? I think it's because we overly always as Kenyans politicize positions and institutions, and everybody wants to be able to choose somebody they think will play the game to their advantage. And I think that's why commissioners unfortunately get kicked out every time. And now the focus has left even the commissioners. They are now even putting their, focusing their attention on the staff of the senior staff of IEBC. And we are yet to see the end of this. And I think some of these things just need an end. We need to say, these are individuals, allow them to work, give us a system that works, that you can trust. Because definitely in Kenya, our politics to large extent is very ethnicized. And because of that, if you read Odede, you will read ODM, despite the fact that I do not belong to that political party. If you read Ngugi, you'll read Jubilee, despite the fact that he belongs to NARC Kenya. So that is just the unfortunate thing with Kenyans. So that when I apply for that IEBC opportunity, even the people interviewing me will be saying, like, we see at a support to kwake. And that's the problem that we inject into the IEBC. But I think time is right for us to focus on systems and processes and leave the individuals out of it. I think it's time for that. Ngugi raises the questions of the women rep and moving to Senate and access to NGAF, the National Government Affirmative Action Fund. Very valid points there, Ngugi. I think it's not a very brilliant idea to do away with the 47 county women and pretend to take them to the Senate to achieve the same result. We need women in the National Assembly as well. So first of all, just taking away the women's seats out of the National Assembly and then pretending to locate this in Senate without telling us how the two-third gender role will be met is neither here nor there. Secondly, the role played by the National Assembly gives the legislators in the National Assembly a lot of presence at the county and constituency level. And actually the legislators in the National Assembly have a great grassroots touch and actually impact on the socio-economic rights of the individuals at the county. So that returning these women to Senate is just actually weakening the position of women within leadership in the country. And I think it's not a good move. It is something that should be resisted. And probably it actually makes them flag girls, something we must also resist. Thank you very much.
Thank you, Council. As we draw towards the end, I see Techno still has his hand up. And Techno, kindly take the airwaves. I hope now you are sorted with your network.
Madam Odede, yeah, can you hear me, please?
Yes, I can. Yes, I can.
Yeah, I wanted to explain something about this thing called the single member and the mixed member constituencies. Because we know that the Article 1 of the Constitution talks about power can either be exercised directly or by delegation. So these are the 70 members. How are they going to be answerable to the members of the public? Because they are talking about 360 elected members of parliament, but you only have 290 constituencies. I wanted if you can expound on that one.
Get others, because nobody other than Techno has the hand up right now, Council.
Okay, thank you. I think you must have missed part of this when we talked about it earlier. I explained that the mixed member representation focuses on population density. So what they're proposing is that we have the 290 constituencies as we currently know it, and then we look at the last census, which data is also disputed across the divide. And going by the last census data, we look at areas with the highest population densities, and then those areas shall be given double or triple constituencies. Now, looking at that data, the 70 seats will actually be allocated among 62 constituencies. So there are going to be at least 8 constituencies with 3 members of parliament. I don't know how workable that is, because even just the process of having 2 MPs in one constituency is a conflict point, because they are definitely not going to work in tandem. They're going to be fighting each other. I don't even think that it's a healthy thing to have for the country. Secondly, this representation of 62 constituencies is only located in 26 counties. So again, 20 counties are marginalized. Now, when we look at the constitution and we look at the factors to consider when delineating constituencies, it is not just the population density that's a factor. So giving a double representation just on density is already a flawed way of thinking. The factors to consider are very vast. It looks at the size of the constituency. It looks at some historical issues around that constituency. It looks at water resources, pasture resources. There are so many factors it looks at that are to be considered. So this style of creating more constituencies or more representation for certain groups of people based just on one factor is definitely a flawed way of thinking. It is also consolidating power in certain regions. If you look at that structure, you will see that about 40 of those seats come from one part of this country. And I think that is something that Kenyans need to also be scared of, because then that part of the country can consolidate their power and vote in the National Assembly to the detriment of the rest of the parts of this country. So it is not a good thing. It's not something we encourage. And as I said earlier, it's also not concretized into any proper document to show us how it will be done and done subsequently. So I think we must just call out some of these things as we go ahead. Thank you very much.
And thank you. Mongela Francis, kindly take the airwaves.
Thank you very much, Mr. EUD. My question is that if we go in an election and there's a scenario whereby, like 2007, where the opposition had many seats in parliament, and the run-up in the BBI, it says that the person who will be the second with the votes will be the prime minister, will be the leader of the opposition. And what if the party that produces the leader of opposition has many seats in parliament? What will happen? Does it mean that we will not have opposition in the parliament? Or what will happen? Just if a scenario repeats itself, like 2007.
Thank you, Francis. Council, you are aware that at that time, the president was inadequate. So that is the issue Francis is raising. How?
I hear him. I hear you, Francis, and you raise a valid concern there. But if you look at the proposal is very clear that the runner-up shall be the official leader of opposition. So whether he has more seats or not, as long as he has at least 25% of the seats, he's still going to be the leader of opposition. Now, look at the draft again. Who is the leader of government business? The leader of government business is appointed by the president. So he cannot be the runner-up. The runner-up will be official leader of opposition, even if he has 80% of the seats. The only thing they can do is frustrate the president's choice of a leader, the prime minister and leader of government business. But the leader of government business will be appointed by the president. I do not think that one party in Kenya can have at least 80% of the seats, and the votes in parliament will always be swayed by the independents and some of the smaller parties. So it's unlikely that there'll be a conflict in identifying a prime minister from the president's side of the divide. Thank you.
Okay, thank you, Council. Looks like I don't have any people raising concerns. From my end, Council.
Yes.
We are in a country that we love, but it appears like there are individuals who want to throw us to the dogs, Council. Looking at this document and knowing too well how hard we have fought to be where we are, what harm will it do if tomorrow I get annoyed and go to the High Court just to do a Nokia Umtata BBI?
In fact, I am shocked Okia is not in court already for this document because it's one of our safeguards and safety nets that are still out there.
So you are saying that where we are, and knowing that we are vulnerable, because certain forces appear to be coalescing with a hidden agenda that most of us don't know, that the courts are the only other avenue. Thank you for sharing my fears. And colleagues, if nobody has anything to add, I want to invite the deputy chair and then invite Isaac, and then I'll give my closing remarks. Kabala Kile, kindly say your closing remarks.
Hi, how's everyone? Thank you, Sana Wakili, for the analysis and description of the BBI report. I know my friend Francis Mongela now amepata majibu zile alikuwa akiuliza kila wakati kwa ofisi, and even some of most of us. And I also thank CMD for giving us this opportunity of being able to share these ideas and enrich or not, or otherwise, towards the document. And also great thanks to you and everyone who's been here. Thank you for being with us. Thank you for being active. And let's spread the word in as little, the small areas we are in our wards, in our family meetings, in our funerals. Let's just spread the word and let everyone know. Let's be the agent that Kenya wants and what we believe in. Asanteni na kwa haya machache, muwe na siku njema.
Isaac, where you are before I issue my
Director Tabu?
Isaac.
Yes, I can take the... Sorry, Director?
I was requesting that CMD say something before I give my parting shot.
No, you can give a parting shot and then I will do some closing because Franco Range may not be in a position to join us.
Okay. Yeah. And now, colleagues, you are aware that we found the document to have a lot of defects, and our hashtag has been reject BBI. I think we are now more emboldened. Let's believe it. And let us spread the gospel, because BBI is not for us, and BBI is clawing back on the gains that we have made, and especially the affirmative action areas where we expect that the party and the country is supposed to be forging ahead. We will believe that as we continue having this conversation within our own areas of influence, let's help Kenyans to understand why we are saying reject BBI. You have heard it from an expert's position. You have also heard it from our own leadership of the party. And it is important for us to ensure that as we say reject, we help people to understand why they reject. I want to thank CMD also. I want to thank each one of you for your engagement and time. and we continue the conversation because this country is ours and we cannot leave it for anybody. Over to you, Isaac, for administrative issues.
Thank you so much, Director, and the leadership of NAK Kenya Party, the Deputy Chair, and all the members of NAK Kenya Party. And we are delighted for you taking time to be part of this discussion in regards to the Building Bridges initiative. And we believe that this is just the beginning of an intra-party discussion and reflection on the BBI document. Yeah, the BBI has a good the recommendations are those that are geared towards the institutionalization of political parties, but the conversation is still going on. It is not a document that we believe has been cast of stone. It is our hope in CMD that the party members and the citizens at large are going to be able to make informed decisions, because in this sector we are in, we have to continue safeguarding our democracy. We have to continue safeguarding the practice of institutionalizing our political parties as institutions of governance. So from CMD Kenya, we are delighted. Rosie Nodede, thank you so much for your professional input in this discussion. And to the Kenya Party members, asanteni sana. Pass our regards to the party chairperson, and we are delighted so much. You can now live on our own pressure, na Mungu wabariki. Asanteni sana.
Asanteni na weekend njema.
Twashukuru Council.
Asanteni sana. Kwaherini.
Bye bye.
Bye.
For the second.
Asante.
Asanteni nyote.
Bye.
Bye bye.
Thank you.
Bye.
Bye. Thank you so much. Bye. Thank you so much.
Keep the fire burning.
Bye.
Thank you.
Bye,
and
everybody. Bye,
Bye,
everybody.
Bye,
Yeah, thank you so
Mheshimiwa
much for.